One. Very good morning. Sorry, very good evening, everyone. This is Dr. Sanket Charkha from Senior Institutes and the Savitribai Phule Pune University. We are starting with the second topic of legal aspect of business. First chapter we have understood or we have dealt with what is the concept of Indian Contract Act, and second chapter we are dealing with the Sale of Goods Act 1930. We have understood or we have seen with respect to the last lecture that is available with you in what is contract of sale and what is essentials of a valid sales. Then we have seen what is the definition of buyer and what is the definition of seller with perspectives of section 2.1 and section 2.13. Conditions of sell and agreement to sell. Then we have seen essential elements of a sale under Sale of Goods Act. Minimum two parties, subject matter is goods only. Consideration, price is promised or paid. Transfer of property, absolute or conditional sale, and other essential elements of a contract. So whatever all other essential elements of a valid contract are applicable, that all thing has to be considered and has to be complied with. Formalities of contract of sale, that is subject matter under section 2.7. Effect of destruction of the goods. Transfer of property, that is it means a specific, that is a special property and not, sorry, it means a general property and not a special property. Transfer of property in terms of immediate or in terms of part or installment. Price consideration under section 9 and 10, that is a particular consideration may be completed immediately or a consideration may be at a certain future date. Stipulation as to time, that is in section 11 considers about when a contract has to be performed. So a particular contract has to perform when it becomes due, and accordingly as per the terms and conditions or as per the mutual agreement between the parties, the stipulation as to time has to be fulfilled. Definition of contract of sale, section 4.3. If a property and goods is transferred immediately from seller to the buyer, the contract is said to be a contract of sale. So here transfer of property is of a major concern. So at every stage we have to see or we have to identify when the property and goods is been transferred. If it is been transferred immediately, then it is an executed contract. It is a contract of sale. If the property and goods is being transferred at a certain future date, then that particular condition is a certain case wherein the contract cannot become into existence. It will be called as an agreement to sell. Type of contract, that is classification of this particular contract, falls under the category of executory contract. So contract of sale is an executed type of contract, and agreement to sell is an executory contract. Difference between sell and agreement to sell, we have seen around 5 to 6 points, wherein the differentiation between sell and agreement to sell was provided for you. Now going further with the concept of sale and hire purchase. In terms of hire purchase, what does the contract is into existence? A contract in which seller agrees to transfer the property and goods on payment of certain sum in a certain fixed installments. It is called as an hire purchase agreement. So if the installment fails, then accordingly the contract or the agreement is not completed and cannot be executed. So here in this case, we have to understand about what is the terms of payment. In case of a contract of sale, you make the payment immediately and the property and the goods is also been transferred immediately. But in case of an hire purchase system, in case of hire purchase, what happens? There is a certain situation wherein unless and until you complete all the installments of the particular payment, the property is not transferred for you and you do not get the ownership rights of that particular property. Sell and bailment, only transfer of possession, no property and goods has been transferred. So anything that we hire on rental basis, so that particular concern, I think, or goods or services that have been hired on a rental basis, or that case is the concept of bailment. So bailment contract can be into existence only when the goods are being given for possession and not for ownership's right. So no possession, no ownership is into existence, and you do not have at certain stages, you may have the custody of goods and you may not have the custody of the goods also. So just the goods may be on your own name. Sell and barter, that is exchange of goods to goods, services to services, money to money, and so on. So if you want to purchase wheat, then in return you have to give jawar, bajra, rice, dal, pulses, and so on. And if you need any of the goods or commodity, then in return you have to provide goods only. In case of monetary transaction or the value, you can exchange the goods for value, money to money, value to value, and so on. Now, coming with the today's perspective, the topic for discussion for today is the concept of condition and warranty. So under condition, section 1211 specifically deals with a certain concern wherein a condition is a stipulation to the main purpose of contract, the breach of which would give rise a contract to be treated as repudiated. So in this case, for example, what is the condition? Now, usually whenever we enter into any contract or whenever we purchase anything, what do? We check for the terms and conditions of that particular contract, or we ask for a certain concern to that particular person. Do we have a warranty card? So, or do we get a certain warranty? So there is a major difference between what is a condition and what is a warranty. So everyone must have to be very clear about what do we mean by condition while purchasing the goods and what do we mean by warranty while purchasing the goods and services. So what is a condition? A condition is a stipulation. Now stipulation means a compulsory, a mandate, because due to which the main purpose of the contract. So a condition is a stipulation, a certain consent which is a mandate. It is a compulsory. The main purpose of the contract, the breach of which would give rise. The breach in the sense, if any of the parties of the contract is not performing his promises respectively, and whether they are conducting actual breach or anticipatory breach. Now, breach of contract, you have already referred in terms of Indian Contract Act, that is the last perspective, that is at the time of performance of the contract. The contract may not be performed based on the consideration of the breach of contract. So, if the breach of contract is been arising, then and from those perspectives, we can come into conclusion that a condition can be into existence. So, breach of which would give rise to a contract to be treated as repudiated. So repudiated in the sense the breach of which. Now if the breach of which means if the breach of a condition is been into existence, if the stipulation is not followed, if the stipulation is not undertaken, if the stipulation that is a compulsory or a mandate is not undertaken, then accordingly it would give rise to a contract to be repudiated. Now repudiated means specifically cancellation of that particular contract. So without this the contract cannot take place. So it is compulsory, it is mandatory for you to conduct this particular transaction or to conduct this particular activity. Gives the rights to cancel and compensation. So here at this stage you get a certain right, whether you are a buyer or whether you are a seller, you have a certain right to cancel that particular contract, and accordingly if any losses has been incurred, if any amount is been expended, then accordingly you can claim for the compensation or you can claim for the damages also. So in this case, what is the condition? Condition is specifically a stipulation. So this particular word, that is stipulation, breach and repudiated plays an important role whenever you write a particular definition in your examination. So stipulation to the main purpose of contract. Now what is the main purpose of this particular contract? That is without this the contract cannot take place, without this the contract cannot happen, and it is mandatory, it is compulsory required for conduction of this particular contract. Now let's take an example. For example, earlier also I have quoted this particular example. Now just repeating from the purview of the condition. Now take a situation wherein recently I have purchased a new flat, and when this particular flat was been purchased, I have hired a interior designer. Now based on the interior designer suggestions, my entire flat was been decorated, and this particular flat that was been decorated, at the end of the day what happened, the interior decorator gave me a certain suggestion in terms of kitchen. Now the suggestion in terms of kitchen that was been given, that so it will be very better, it will be very good if the refrigerator color will be of red specifically. So what was the suggestion? My stipulation to the main purpose of contract. So stipulation is, if I want to make my flat look good, very decent, very nice, in a very decorative way, according to the expert that was been appointed. Now who is that particular expert? The expert that has been appointed, the suggestion that was been taken from the interior decorator was specifically that if my kitchen needs to be in a decorative stage, if my kitchen needs to be look very good, then the refrigerator must be specifically of red color. Now based on this particular suggestion, what happened, I went to a particular shop, a particular store, and I've placed him a certain order that please send me the refrigerator of so and so specifications of red color only. Now at this stage, where if I have said him specifically that I want the refrigerator of red color only, then what is my consideration? That the condition has to be fulfilled. So what was my condition? I want a particular flat to be looked in a good condition, in a decent way, and must be in a good decorative way, which is designed interiorly by a certain expert. So based on the expert suggestion, my flat will be looking very good only when the red color will be fitting into those particular position. So and by coincidentally or by mistake, what happened, the person or the trader or the particular seller does not give me the red color, and he provides me the refrigerator of black color or blue color. So here and at this stage, what can happen? At this stage, we can identify that I have a certain position, I have a certain option, that on the basis of condition of that particular contract. So my contract was based on a certain condition that if I want to purchase the refrigerator, it must be of a red color only and not of any other color. So in this case, we have to identify about what is the condition to this particular contract. If the condition is fulfilled, then the contract can be performed, and if the contract condition is not fulfilled, then the contract can be repudiated. Repudiated means it can be either cancelled or I can claim a certain compensation. Now, provisions relating to transfer of property and titles under the Sale of Goods Act. So, it is having, now what is the meaning of transfer of property and transfer of title under SOGA? Through effect, transfer of property as between seller and buyer. So at every stage, whenever we are conducting any transaction between a seller and buyer, we have to answer, we have to understand, we have to take proper care about the transfer of property. Now, transfer of property means either you are transferring the general property or special property in goods. General property specifically means that you get a complete ownership rights and you get a certain authority for using the goods for a longer period of time or for lifetime. So here always the transfer of property is always from the seller to the buyer, and whosoever is purchasing the goods and services from one person to another person, the property gets transferred, and always the property must transfer from the seller to the buyer and not from buyer to the seller. So in this case, three effect is always needed to be identified. Transfer of title also. Now, first thing what we are looking for, transfer of property means you are actually delivering the goods and services from seller to the buyer. Transfer of title on goods. Now, transfer of title on sale. Now, what do we mean by transfer of title on sale? That is the bill that is being generated or the document that has been created. So, whenever you purchase any goods, any commodity or any services, what do? We ask for a receipt or we ask for a bill that has been auto-generated or which has been manually created. So, whenever a particular bill or a particular quotation or a particular receipt is being created, then on this particular concern, what we do, we can identify that I am the owner of these particular goods and services and the goods are on my name. So that particular name specifically means the title of goods. So title of sale means earlier the ownership right, earlier the owner of the goods was a particular seller and now it has been transferred to some another person and the title has been transferred from seller to the buyer. So what does the title mean? Title means the name that has been identified on a particular product or on a particular commodity. So transfer of title on sale specifically means about from the transfer of name from one person to another person. Transfer of ownership rights. Transfer of ownership rights means what rights do you have to use that particular product. So using after that particular product specifically understands or specifically means about how you can use that particular product. Now sale of goods act specifically deals with a certain concern wherein you are actually selling the product. Now whenever we say that we are selling a particular product, we get the right in full. So always the ownership rights must be transferred in full and not in partial stage. While understanding the transfer of property, what we were looking for, we have understood that the transfer of property must also be in a general case and not in a special case. So there should not be a reserved category or a reserved concern of the concern of transfer of property. In the same case of the ownership rights, the ownership rights also specifically mentions or specifically concerns about how you have ownership over that particular goods. We cannot say that I can use 50% of the goods and rest 50% of the goods cannot be used. I cannot say that these particular goods can be used for 1 year and after 1 year I cannot use these goods. So this is the case or this is the understanding that what ownership rights do you have. Once you purchase a certain goods, you becomes the real owner of that particular goods and services, and for a lifelong period, for a unlimited period of time, you get a certain right, you get a certain authority to use those goods and services. So in this case, we have to identify major three concepts or major three components about what is the title in goods, what is the property in goods, and what is the ownership right that you are getting while transferring or while selling the goods from one person to another person. Now, example, Mr. Ram agrees to sell a car to Mr. Sham, wherein Sham says that I need a vehicle to be used for a tourist purpose, but later after using, he finds it unfit. So he has the right to reject the goods and claim damages for it. So here let's take, I have taken an example wherein Ram and Sham are the two partners and Ram agrees to sell a car to Mr. Sham. Now, if at this stage, if Sham has specifically mentioned that I need to purchase a vehicle and that particular vehicle must be fit for the consumption or fit for the tourist purpose only. But later after the purchase, what happened? Mr. Sham finds that the vehicle or the car or the tourist bus that he has purchased, it is not fit for consumption, it is not fit for use, and accordingly it is defective. So at this stage, what option is available with Sham? The right that Sham has, he can again refund that particular product and he can claim the damages from Mr. Ram accordingly. So in this case, whatever purpose, whatever motive that you have identified, it must be completely fulfilled, and that particular purpose or motive, whenever it has been fulfilled, it must be obtained in that particular terms and manner only. Now, if it has not been fulfilled, then you have a certain right to cancel that particular contract and accordingly claim the damages or compensation from the respective parties. Now let's look at the next perspective, warranty. So what do you mean by warranty? Yes, anyone? Can you please tell what do you mean by warranty? Whenever we purchase a watch or electronic device, anything whenever we purchase, we ask for a certain product that bhaiya iski warranty hai kya? What do we actually mean to say him?
If there is any
Secrecy.
Yes.
Shilpa
in
says,
case the product, how the long the product are staying or maintaining. This is
Yes.
meaning
How long the
for
product is staying or maintaining. Okay. Next, Shilpa.
if there any defect or something like that happens within the certain
Ah,
period,
uh-huh.
they will provide us some services. It is called
Right.
warranty.
Within a certain specific period, if there is a certain defect, whether they will provide services or not. Yes. Another one who was saying Soham, I think. So now let's go to the definition about what do we mean by warranty. So under section 12.2, a condition is a stipulation collateral to the main purpose of the contract, the breach of which would give rise to claim the damages but not reject the goods. Sorry, here the definition is warranty. I need to change it. So read in this way. A definition of warranty as per section 12.2, a warranty is a stipulation collateral to the main purpose of contract, the breach of which would give rise to claim the damages but not reject the goods and cannot be treated as repudiated. So secondary importance. So primary importance is always for a condition and secondary importance is always provided for a warranty. Now, what is a warranty? Warranty is a stipulation. Same. A condition was also a stipulation, and warranty is also a stipulation. But condition is the main stipulation, whereas warranty is a collateral stipulation, which is always the main purpose of this particular contract. Now, breach of which, any party to the contract may conduct a breach. That is, you went to a particular shop and you suddenly you said that. Hello, sir. I want to purchase a watch. Now, whenever you go to a Titan store and you purchase a particular watch, what happens? The store person or the salesman says you that there is a warranty of 2 years. That within a period of 2 years, there will be no damages or there will be no maintenance cost for this particular watch that you are purchasing. Now, the watch costing rupees 5,000 that you are purchasing and it is having a warranty period of rupees for a period of 2 years. Accordingly, what is the condition? There was no condition that was been associated. You have just purchased a normal watch. But what was made available? Collaterally, the seller has given you a certain condition. The seller has laid a certain warranty stating that this particular watch will be working in an effective condition. There will be no damage for this particular watch over a period of time that is maximum of 2 years. So always it is collateral. Collateral means it is not associated with the main purpose of contract. So condition is always a stipulation that is a mandate for a main purpose of contract, but warranty is not related or not concerned with the main purpose of contract. The breach of which, now if any of the party to the contract is conducting the breach, now usually in terms of sale of goods act, the breach has been conducted in terms of condition and warranty by the seller itself. So the seller is usually found to conduct a breach, and at this stage, if a breach of contract has been conducted, then under the terms of conditions of warranty, under the purview of warranty, you have the right to claim the damages, but you cannot reject the goods that have been asked for, that you have got the delivery. So here in this case, whenever warranty comes into picture, you cannot reject the goods, you cannot refund those particular goods also, but accordingly the particular person can change that particular goods, and a small rectification in this particular contract can be done. Accordingly, whatever damages have been required, whatever changes in the particular product have been required, the maintenance will be done for that particular goods and services, and accordingly the goods will be same refunded back to you, and the contract cannot be treated as a repudiated or a cancelled contract. Secondary importance. Now, why? Because we cannot repudiate this particular type of contract. So if a particular contract cannot be repudiated, then we can say that a particular contract is into existence and it is of a major importance, not of a major importance, and it is of a secondary importance. Only claim damages. So here at this stage, what can a person, that is the particular person who is aggrieved to this particular contract, the buyer, what he can do, he can only claim damages, and accordingly he cannot claim the entire product. So if I purchased a watch of rupees 5,000 from Titan, then accordingly I cannot say to that particular person that entire 5,000 amount has to be refunded to me. But what he can do, he can just repair that particular part that is damaged, and accordingly the major or the minor corrections in the product can be done, and the same product will be refunded to me. Your intention is important. So here, now in this case, what is your intention? Now your intention identification is very important whenever you are identifying the, either it is a condition or either it is a warranty. Now, if your intention is from a certain concern wherein the main purpose of contract is getting violated, then it falls under the purview of condition. Now, in case of if a certain intention is falling on at a collateral stage, that is at a secondary stage, then here it falls under the purview of warranty. So, intention of the party, that is intention of the buyer, is is a major concern that you have to identify, and based on those concern only, it can be identified whether it is a condition or whether it is a warranty. Now, example we have taken, Mr. A purchases a refrigerator from Mr. B, the retailer who says it is frost free, but later after 6 months find it is not accordingly. Hence, he can get repaired and cannot get replaced. So, example that is given with that is Mr. A goes to a particular store and accordingly he says that I want to purchase a refrigerator. So, a Whirlpool refrigerator was being purchased, and while selling this particular refrigerator, the particular person, the seller has, that is Mr. B, has specifically said that it is a frost free refrigerator and the warranty for this particular refrigerator is for 2 years. Now, but after consumption or after using this particular refrigerator on a daily basis, what happened after 6 months, it has been found out that the refrigerator is not frost free, and in the cooling section or in the freezing section, accordingly the frost starts settling. So at this stage, what happened? The stipulation now here, your condition or the refrigerator that you have purchased, you have not mentioned specifically what is the main purpose of your contract. You have purchased this particular refrigerator to freeze any of the amount or any of the commodity that you can store at that particular place. So here, frost free was a collateral purpose to this particular contract. For frosting position or freezing position is a one of the sector of that particular refrigerator, and within that particular sector, if a particular defect has been identified, then only that particular defect, that is a small defect or a small portion of the particular product, gets repaired or get altered, and entire refrigerator do not go for repairs and maintenance. So here we have to identify what is the main purpose, whether it is associated with the main purpose of the contract or whether it is a collateral purpose to the contract. And based on those concerns, we have to identify whether it is a condition or whether it is a warranty. Now here in this case, if a small manufacturing defect is been identified, then only at this particular stage we can get that particular small manufacturing defect repaired, and accordingly the product will be again delivered to you back to this position, but the entire goods will not be replaced. Your intention is important, for what purpose or goods or reason the goods are being purchased. So what is the purpose, what is the intention of purchasing those goods and services? Only on that concern the goods will be altered, and no additional conditions will be accepted about how you are trying to purchase these goods and services. So we have to identify what is the main purpose of this particular contract, what is the collateral purpose to the contract, and based on those concerns we have to think of whether it will fall under the purview of condition or whether it will fall under the purview of warranty. Okay, any difficulty at this stage in understanding condition and warranty? You can quickly ask me questions, otherwise we'll move to the next slide. Now, the differentiation between condition and warranty. So condition is essential to the main purpose of contract, whereas warranty is collateral to the main purpose of contract. The aggrieved party can repudiate the contract and claim damages, or in both cases, or in both in case of breach of condition. So if a breach of condition is being created in terms of condition, what a party can do? The party can claim damages also, and the party can completely change the product or alter the product that he has received. But in case of warranty, only damages can be claimed, and accordingly the entire product cannot be changed or cannot be replicated by the particular party or by the particular buyer who has purchased those goods and services. So in this case, we have to identify what is the major differentiation, what is the condition with respect to the breach of a contract. So in case of breach, the damages and the compensation both can be claimed by a certain person who is under the purview of condition, and in case of warranty, only damages can be claimed. No amount of compensation or no amount of change in the product, that is actual physical product, cannot be changed whenever it is been required. So, and the third point, a breach of condition can be treated as a breach of warranty, but a breach of warranty cannot be treated as a breach of condition. So what is the meaning of breach of condition? That entire contract stands cancelled. But in case of a breach of wherein if a particular breach has been conducted in terms of a condition, then at this stage you cancel the entire contract and you do not wish to perform the promises further, and accordingly you want to cancel entire of the contract. Now, whenever we are cancelling the entire contract, what happens? You refund that particular product, you can claim the damages, and you can get the compensation from the respective seller. But in case of warranty, warranty is a stipulation to the main purpose, collateral to the main purpose of contract. So always it is associated with the collateral security, that is whether a product may perform or a particular product may not perform. So you are not sure about the performance of this particular product, and you want to see about that at what stage, that is for a period of 1 year, 2 year, 5 years, at what duration the product will be able to perform in an effective way. So if the product does not perform effective in that particular way, then accordingly only small portion of the repairs and maintenance can be undertaken, and entire product will not be refunded for you. So in this case, we have to identify about the breach of condition in case of what is a condition, what is a warranty, and what is included in what. So in terms of condition, breach of warranty is being included, but in case of warranty, breach of condition is not included. Now, exceptions to general rule. So what are the general rule for the now here, whenever we are understanding or whenever we're dealing with the concept of Sale of Goods Act, the major identification, major concerns was with respect to the possession, with respect to the ownership, and with respect to the title of goods that has to be identified. Another exceptions that have been provided to the general rule are with respect to the are with respect to the fitness for buyer purpose. So buyer makes known sale to the purpose of buying the goods and purchase and services. So whenever you are purchasing any of the goods and services, or whenever a particular seller is selling any goods and services, it is duty of the buyer and it is duty of the seller to inform, that is both the parties must inform each other about what is their purpose of purchasing the goods or what is the purpose of selling the goods and services. Now here, what does the law do? The law, that is Sale of Goods Act, specifically gives a certain consideration about the responsibility of a particular buyer. It is completely the responsibility of the particular buyer to inform the seller that for what purpose he is purchasing the goods and services. Now, for example, if you are going for if you go out, if you go on a particular shop and accordingly you say that you just tell that you please provide me poison. Now, whenever at this stage you are asking a particular product, you have to be very specific. The poison has to be used for what purpose? That is, the poison has to be used to kill insects. The poison has to be used to kill mosquitoes. The poison has to be used to kill a particular person, that is an animal or a human being, and so on. So what is the purpose? For fitness for the buyer purpose, it has to be, it is completely the responsibility of the seller to inform responsibility of the buyer to inform the seller for what purpose he is using those goods and services and he's consuming those goods and services. So in this case, fitness for buyer purpose. Now it is complete. Now another reverse situation that the law also provides, that it is duty of the seller also to identify, to claim, and to inform that particular buyer about in what manner the goods has to be consumed. So for example, if a poison is been delivered from by the seller to the buyer, then he also has to inform about what is the proportion, what is the quantity that has to be consumed. For an insect, what quantity has to be implemented. For an animal, what quantity has to be inserted. For a mosquitoes, for certain other type of insects, what quantity you have to use. And for a human being, what quantity has to be consumed or what quantity has to be used. So at this stage, what is the purpose of purchasing those goods and services must be identified, and accordingly it must be communicated to both the parties. Now, at this stage, if it has been identified or if it has been known that both the parties have not performed these particular concern with respect to the information that has to be exchanged or that has to be shared, then accordingly we can say that it is not an effective contract of sale. So if a particular person or if a particular contract has been identified that the buyer also has not informed, or the seller has also not informed about what is the purpose of that particular contract, then accordingly the contract stands repudiated and you can properly cancel that particular contract. Buyer relies on skill and judgment of this particular seller. Now, understanding this particular position, if the buyer has specifically mentioned which type of goods and services that he need. Now, based on this concern, what does the buyer do? Buyer completely relies on that particular seller's thinking or having a certain perception or having a certain over mindset that whichever goods have been demanded for me, the seller will provide the fitment, that is a fit goods that have been required for me according to my need and requirement. So if you are saying that a particular poison has to be provided which kills a certain type of insects or which kills a certain animal within 5 minutes or 10 minutes, then accordingly the seller has to provide that particular type of goods only. And accordingly, the buyer also has to rely on the skill set that have been available or the judgment that has been given by a certain seller about which quality, type, and quantity of product that has been delivered to you. Goods must be of description which is at the course of seller's business to supply. So always, if the goods have been sold on the basis of description, then the buyer has to rely on seller's concern that has been completely mentioned. So if you went to a particular shop and accordingly you said that please provide me cotton clothes, then accordingly you have to rely on a particular seller that he is providing you or he is delivering you the cotton goods only. So completely it is a discretion of that particular buyer to remain dependent on that particular seller, and whatever goods have been provided, it is your duty to properly check those goods and services, and accordingly if you find it fit for your consumption, fit for your utilization, or fit for your daily purpose, then accordingly you can purchase. Otherwise, the contract can be repudiated as and when the need arises. Now, there is a certain case study with respect to Manchester Linears versus Ria Limited. Now here Manchester Lineage was a particular company. Everyone must have heard of a company called as in Manchester, and Ria Limited was was an Indian firm wherein they used to manufacture, or they used to produce tan of a very huge quantity. Now, whenever this particular tan was being manufactured, Manchester Lineage specifically mentioned that they want to stitch uniforms for blue collar job and white collar job. Now, and for this particular concern also, the color was also being specifically mentioned. For a blue collar job people, the dark blue color was being identified, that is, and for a white collar job people, the white trouser and the black trouser and a white shirt was specifically mentioned. So in this case, whenever a particular order is being specifically mentioned, and for the quality of product, now when the blue collar job the uniform was to be stitched, the quality that was being provided was also different, that is the cloth that they have to use. And for the white collar job people, the cloth that they have to use was also a completely different cloth. But what Ria Limited do? Ria Limited did not understand what type of business conditions was being laid, and he stitched, that is the company stitched both the uniform, that is the blue collar and white collar jobs of the same type of cloth that was been mentioned. At this stage, if it has been specifically mentioned about what type of cloth that you have to mention, we have to take into consideration about what type of goods and services has been specifically mentioned, what quality of cloth that you have to use, and if the cloth is not being used according to your terms, according to your quality, then we can come to a certain conclusion that the contract can be reputed and is a breach of condition on those perspectives of a particular seller. Merchantable quality of goods. A seller who sells goods by description is bound to sell the goods of merchantable quality only. Goods are not merchantable if they cannot be used. Example case of hot water bottle. Now, for example, merchantable quality of goods. That is, you go to a particular store, and accordingly, whenever you visit that particular store, what the particular seller will do. Excuse me. Hello. हाँ. आमची नाही आहे. हाँ. हो. बरोबर, ठीक आहे, ठीक आहे. हां. आणि ते अश्विन गोत्रेचा मेल आलाय, त्याचं काय? एक मेल फॉरवर्ड केलाय ना त्यांनी. बरं, तो म्हणतोय की माझा झालं नाही व्यवस्थित आणि हे ते. हो. हं, हं. हं, हं, हं. हं. हो, ते आहे. हो, हो. हं, हं, हं. मी हे त्याला ऑलरेडी आय हॅव इन्फॉर्म दॅट पर्टिक्युलर. Okay, sorry for the interruption. Now, merchantable quality of goods. So, merchantable quality of goods specifically means about what type of goods are available based on the description. Now, you went to a particular store, and whenever you went to that particular store, you want to purchase wheat or a certain example of rice. Then, whenever you want to go to a particular store for purchase of rice, what happen? There are various description counters. There are various counters or outlet that is mentioned, and a particular display poster is also been mentioned that which wheat or which rice is of which quality, and what is the pricing of those particular goods and services. So it is completely the duty of that particular seller. So a seller who sells the goods by description is bound to sell the goods of a merchantable quality only. So whenever a particular seller is displaying certain goods and services on the counter, it is his responsibility, it is his duty to identify that the goods are of a merchantable quality, that is, the goods are of a good quality only. So the goods which are defective, the goods which are not fit for consumption or fit for use, that particular type of goods must not be displayed at that particular counter. If a particular buyer on his own, if he insists that I want a product of the lower quality or the lower quantity, then accordingly the goods must be portrayed, and and if it is not been demanded, then accordingly the goods must not be portrayed. Example, that is case of a hot water bottle. Now, whenever you enter a particular store, and accordingly you specifically mention to that particular store manager that I want to purchase a bottle wherein the water will remain hot for around 2 to 3 hours. Now here, your condition for that particular concern was specifically mentioned, your description of the goods was specifically given, but what happened based on the customer acquisition, based on the demand for the goods and services, based on the rush into that particular store, the particular person, that is the seller, he handed over a random bottle to you, and accordingly that particular random bottle that was been handed over for you, it is not a preservative bottle for a hot water. Now you went to your home and accordingly you find that the hot water bottle was not into existence, and accordingly the water does not remain hot for around 30 minutes also. So in this case, you can go back to that particular store and accordingly the goods can be replaced based on your certain condition that you have laid for that purchase of goods and services. So in this case, if the goods are of a merchantable quality, if the goods are fit for your consumption, then only the goods has to be sold. If the goods are of a defective nature, if the goods are requiring certain repairs and maintenance, then accordingly that activity must be undertaken, and then only the goods must be sold for that particular buyer who is also available. Another concern with respect to the concern of display of goods. So only those type of goods must be displayed at your particular store, only which are fit for consumption or only which are fit for your regular routine use. If the goods are not fit for your consumption, not fit for your daily use, then accordingly the goods must not be displayed at that particular store, and accordingly the seller must keep those goods away. Now, the expressed and implied condition and warranty. C&W stands for condition of warranty. SOGA stands for Sale of Goods Act. So, express condition and warranty are those which have been expressly agreed upon by the parties at the time of entering into contract of sale, are expressly provided in terms of contract. So, what do we mean by express and implied? That is, either you expressly tell, that is, you are telling by way of writing, or by whether you are telling in an oral format. So any condition or any warranty, whichever you are telling by way of a oral format or a written format, those type of conditions will be, or condition or warranty will be called as an express condition. Any condition which has been implied, which has been taken for granted by either the buyer or either by that or either by the seller, those particular types of conditions will, or the condition or warranty will be called as an implied condition or implied warranty. Implied condition. Now section 14, 15, 16, 17 deals with the certain considerations with respect to the implied condition. Now express conditions, you need not any explanation, wherein express condition, that is, you are specifically mentioning to that particular seller about what is the description of the goods, why do you need to purchase these goods, and so on. So either it is being provided in a written format or either it is being provided in oral format. It has been assumed that the goods and services will be of that particular category or will be of that particular type only. So in this case, we can identify about what is the express condition and express warranty. Now, implied condition, section 14 deals with the consideration of implied condition as to title. So implied condition, it is always an implied condition on the term of the buyer that always the seller is having a title to sell those goods and services. Whenever we go to a particular store and whenever we purchase any goods and services, we do not ask to a particular seller that does these goods belong to you only or not, or whether you have stolen it from somewhere. What do we assume? Now assumption हमारा क्या होता है? Based on our implied condition that the title of the goods, the ownership of the goods is with the seller only. That is, the seller has went to a particular manufacturer or the seller has went to a particular wholesaler, and from that particular location he has purchased those goods and services. So here purchase word is very important. Purchase in the sense that is, he has prepared a quotation, a bill has been generated, a payment has been done, and only when the payment is done, the property in goods is being transferred from manufacturer or wholesaler to the seller, that is the retailer. So whenever you go to a retail store and whenever we purchase those goods, we do not ask कि भैया आपने ये goods purchase किया or you have stolen these particular goods. So in this case, what happened? Authority to sell. So and when you can get an authority to sell, only when you have the real title to sell those goods and services. And when, how can the title be identified? The title of the goods and services can be identified based on the bill, quotation or invoice that he has, from where he has purchased for. Section 15 of SOGA, that is Sale of Goods Act 1930, specifically deals with the sale of the goods by description. So sale of the goods by description, now you went to a particular store and accordingly a certain description was been given you for a particular product. That is, you went to a mobile or a cell phone store and based on the particular cell phone store, 5 products was been displayed for you. So Nokia cell phone was also been displayed, Samsung, Oppo, Moto and Redmi and Apple iPhone was also been displayed for you. Now, based on those particular consideration, each and every product was been described for you. Now, based on the description that was being provided, what happened? You selected an Oppo phone and accordingly you gave a certain order for purchase of those goods and services. Now, whenever these particular goods was being purchased, what happened? After a point of time, you found out that what product that you have ordered, what category, what brand, what model number that you have added, whatever you have ordered, the product is not according to your order, the product is not delivered according to your order. So at this stage, it is always an implied condition that whatever order you are placing based on the description that has been provided by that particular seller, always the goods must correspond to that particular product only, or that particular description only. So if the goods are not based on your description, based on your explanation that was been given for you, you have a certain right for based on the implied condition to reject those goods and services. Why? Because your condition is getting violated, and accordingly, whenever condition gets violated, you have a certain option for repudiation of that particular contract. So here, any of these condition is not been fulfilled, any of the condition is been not complied for, then accordingly, based on the implied condition of the particular concern, you can repudiate the contract, which means you can cancel that particular contract, and accordingly, you can claim compensation also, and you can claim damages also. Correspondence. Now, another example for correspondence, for example, whenever you go to a particular store, that is when we purchase wheat, or whenever we purchase rice, what do? We go to that particular counter, and accordingly we take a sample into our hand. Now, usually the female members in our Indian culture, whatever, they have a certain habit, or they have a certain practice of taking the rice into their own hand, and they are checking the smell of that particular rice. In case of wheat also, we take the sample of that particular wheat, and accordingly we check whether the quality, quantity, or the description of the goods are accordingly or not. Now, whenever you place a particular order, and accordingly based on those concerns, what happens, the particular lady gives a certain order. That is, please pack 10 kg of rice from that particular counter, which is valuation of rupees 70 per kg. Now, whenever the goods are being sold for you, the maximum number of goods must correspond to the amount of goods that has been given for you. So, at this stage, the sell by description. So whenever a particular description of that particular product has been given for you, you have to see that the goods are of the same correspondence, the goods have been delivered in the same quantity, and it is always a condition on the seller to deliver the same goods and services only. As to quality and fitness of goods, so quality and fitness of goods, which specifically, that is section 16.1, 16.2, and 16.3, specifically deals with the goods specific concern. So quality and fitness of goods specifically mean whichever goods that you are using, always it is a duty of the seller to inform that particular buyer about what is the quality, what is the brand, what is the type of goods that you are purchasing, and whether the goods are fit for consumption or whether goods are not fit for consumption. So always the seller has to inform a particular buyer about what is the fitness of these particular goods. Now, you went to a particular store, and accordingly you asked for a poison. Now, this particular poison, if it is of a which quality, which quantity, and what consumption differentiation matters to the, or it is a threatening to your life, the seller has to completely inform the particular buyer about what are the pros and cons related to that particular product. So accordingly, the quality and fitness of goods, whether the what is the quality, what is the brand, what is the association, what is the fitness of those particular goods, everything must be clearly explained by that particular seller. And unless and until the buyer is having a clear knowledge, clear implications about those particular product, the communication must not be cleared accordingly, or the deed of sale must not be completed. Fitness of goods, the fitness of goods specifically must be mentioned by that particular seller about what quantity of goods must be consumed. That is, the goods must be consumed for rupees 50 milligram, 50 gram, 1 gram, 2 gram, 5 gram, 10 gram, 100 gram, 1000 gram, and so on. So accordingly, the fitness of the goods must also be identified based on the different brands that have been associated, based on the price that has been set for a particular product. It is duty of the seller to inform the particular buyer whether the goods are fit for consumption or whether the goods are not fit for consumption. As to merchantability or usableness, merchantability specifically means, or specifically understands about what is the use of the product, or for what purpose you are using those goods and services. If you are using these goods and services for the daily consumption, for your domestic consumption, then accordingly it is the duty of the buyer to inform about how the goods and services, or for what purpose he is using those goods and services. If the seller is selling those goods and services, he must inform the particular buyer about what quantity has to be used, what quality is being provided, and what proportion of the goods and services is fit for consumption. Now, for example, when you went to a particular shop and you purchased milk, now whenever you are purchasing a milk, it is always assumed, it is always implied that the merchantability of the good, that is, it is fit for consumption, and accordingly the milk will be consumed within 2 hours or 3 hours. So if more than 3 hours or more than 5 hours, if the milk is kept outside, accordingly it gets spoiled, and accordingly the milk is not used for fit for consumption, or it is not of a merchantable nature, or it is not of a usable nature. So always an implied condition. What is that implied condition? That when a milk is been purchased, it will rest for around 3 hours, and after 3 hours only it will get spoiled. Implied condition, that is, whenever you are purchasing a particular cloth or a particular uniform or a particular dress here that you are purchasing for yourself, we always assume that that is on the day one the uniform will not tear, or the cloth that you are purchasing will not tear, and accordingly it will last for around 1 month or 2 months. So in this way, the merchantability of the goods has to be identified. Another example, merchantability or usableness of goods. Very often we purchase different types of clothes, and at every stage, what do we find? Certain clothes means their color get diminishes, or a color is being wasted in terms of water whenever you are washing. So in terms of merchantability, what we can identify, that the color of that particular cloth, or the color of that particular cotton, or whichever you are using, it is getting affected and is getting defective over a period of time whenever you are frequently washing that particular product. So based on the implied condition, it can be identified whether the product is fit for usefulness or whether the product is not fit for your daily usefulness. As to customs or usage of trade, no, if the particular product or the commodity is used for a business purpose, then this it is the duty of that particular buyer to inform that particular seller for what purpose he's purchasing those goods and services. Now if you're purchasing the goods and services for the business purpose, then accordingly you have to see that you have a proper quotation, you have a proper bill, all the taxes that have been associated with respect to the state government and the central government are being paid by the respective purchaser, manufacturer, wholesaler, dealer, and accordingly the retailer is purchasing those goods and services. So for the trading purpose, all the taxes, the goods must be free from encumbrance, and there should be no any charge on those particular goods. Sell by sample. So if your section 17 specifically deals with the consideration about whenever you are purchasing or selling the goods and services based on the sample description. So if your particular sample is being shown for you, what is the rule as per the implied condition, that the bulk must correspond. That is, I give an example of rice. That is, whenever a particular female member, if they are purchasing rice, what happen, what they do, they take the sample of rice into their hand, and accordingly they smell that particular rice and they identify which rice has to be purchased. So based on this consideration, if a particular rice is being ordered for rupees 70 per kg, then whatever quantity that you have purchased, that is, if you say that I want to purchase 5 kg of rice, then accordingly maximum 4.5 kg must correspond to your sample that has been provided. Around 5.5 kg, another quantity can be mixed into it, but the maximum quantity of the product must be correspond to the sample that has been shown to you. As to wholesomeness, that is with respect to the health and consumption. Always the product that you are using or the product that you are purchasing must be of a wholesome nature. That is, whatever terms, conditions that you have been associated, whatever conditions that you have laid for your purchase of those goods and services, everything must be fulfilled, and accordingly only then the goods must be sold by that particular seller. And whenever a particular buyer has been fulfilled, whenever a particular buyer has been satisfied with what description has been given of that particular product, only then he must purchase those goods and services. So wholesomeness means complete satisfaction of the particular buyer, and complete satisfaction or the fulfillment of the particular seller must be there into existence, and only then the contract has to be performed. And otherwise, if the both the party, that is either the buyer or either seller, if they are not satisfied with the terms and conditions, or if they are not satisfied with whatever the contract, in which way it is moving, the contract cannot be performed, and accordingly the contract of sale can stand cancelled. As to consent of fraud, so consent means, now here in this case, what do you mean by consent? Consent means parties to the contract agree upon same thing in the same sense. So if you are saying that a particular consent is in existence, the consent must not be now what we have a certain definition with respect to free consent. The free consent specifically mentions in a negative manner, wherein a consent is said to be free if it is not based on coercion, fraud, undue influence, misrepresentation, and mistake. So if any of the factor of the free consent is into existence, and accordingly if it has been found out that the consent is not given free, then also you have a certain right, you have a certain option for cancellation of that particular contract also. So a consent must be free. If it must not be based on any charge that has been associated, and if it is found, I have given just one example of a fraudulent activity, and if you feel that a particular fraudulent activity has been conducted by either the buyer or either by the seller, then accordingly you have a certain right for repudiation of that particular contract. Why the contract can be repudiated? Because you are forming, or because we are learning the concept of implied condition. So based on the condition, the contract can be repudiated. You can claim the damages as well as you can claim the compensation. Now let's move to the next point, that is implied warranty. Implied warranty. Now what is a warranty? Warranty is a stipulation which is collateral to the main purpose of contract. It is not the main purpose of the contract, but it is the stipulation which is collateral, that is alternative. It is supporting to the main purpose of that particular contract. Section 14B specifically means the quiet possession. Now, what is meaning of quiet possession? That is, you have a full right to use those particular goods and services. Now, for example, you have purchased a cell phone. That is, whenever you go to a particular store, and accordingly a cell phone costing rupees 50,000 was purchased at that place. Now, whenever you purchase that particular cell phone, you bring that particular cell phone to your home. Accordingly, the seller cannot come back to your home, and accordingly he can ask that you have used it for around 5 years. Now, please refund that particular cell phone. So in this case, what is an implied warranty? that is for a period of time. If the particular cell phone is taken on a rental basis, then accordingly the seller can come towards you and accordingly he can charge a particular rent and accordingly the possession of the goods can be taken back to you. But if you have actually purchased those goods and services, then the seller does not have a right to take back the possession, take back the authority of those goods and services, and he has to give the full permission, full authority to use those goods and services. Section 14C of the SOGA specifically deals with the consideration of free from encumbrances. So there must not be any charge on the goods and services that has been created. So whatever goods that you are purchasing, there must not be any bank liability, there must not be any financial liability that has been associated with that particular product. If whenever a particular seller is selling you any type of goods and services, all those goods and services that is been sold for you, it must be of a completely free of nature, and there must not be an additional liability that is being charged. So if a particular bank authority, bank charge has been associated, then accordingly you do not get a free possession, free right and free ownership, and accordingly a defective title is been transferred from a seller to the particular buyer. Now, what is a defective title? You have a separate long question based on this particular concern. So, whenever we understand the delivery of the goods, whenever we will come to title in goods and services, you will be able to understand what is defective title. So, while learning defective title, I'll explain what is encumbrance and what is charge. Quality and fitness for the usage at international trade. So always it is an implied warranty with a certain concern that whatever goods that you are purchasing, these goods that have been purchased are fit for consumption in the domestic market as well as in the international market. That is, for example, if I'm purchasing any commodity as on today. Today I am staying in India, tomorrow I may travel to Europe, and the day after tomorrow I may travel to US, another day I may travel to Australia, and so on. So if I'm traveling from one country to another country, along with me, my goods are also traveling with my position. They are also changing their countries. So whatever goods that you are purchasing at this stage, we have to identify, it is the duty of that particular seller to take into consideration that the goods are fit for consumption, the goods are fit for usage at the domestic level as well as the international level also. And lastly, disclosing the dangerous nature or cause. So if any dangerous nature or cause is there with respect to that particular product, accordingly that particular information must be given by that particular seller to the buyer. So consume within 24 hours. So if you went to a particular store and accordingly what does the seller tells you, please consume the sweets within 24 hours, please consume the product within 1 hour or 2 hours or accordingly. So in this case, what if there is a hazardous nature for that particular product, it is the duty of that particular seller to inform, it is the duty of the manufacturer and the retailer and the wholesaler to print that particular information on that particular product. On certain products, what do you find? That keep away from the reach of children. So certain type of products, certain type of commodity which are harmful for the children, it must be kept away, and a certain notice or a certain warning must be given to the users of that particular product. So in this way, we complete with the concern or the session of condition and warranty as on today.